You just have one today?
Actually, I have two today.
I thought so. Okay. It's 2128, your other abuse that we heard before.
That's correct.
And you have a substitute that strikes everything except the word other abuse.
That's correct. It's actually suggested by Delegate Mark who came for making that.
All right, so we have the substitutes before everybody to 2128. Take a look at it. All it does is strikes that definition of other abuse and just leaves in the phrase other abuse. So it sort of clarifies what's admissible. All right, with that, I don't suppose, what was his name, Tyler?
Tyler, yeah.
Tyler's mom, they're not back.
They're not, but they're certainly very keenly interested in regarding this, and I've been communicating with Ms. Russell all day today, because she and Tyler are very concerned, obviously, about the result. We talked about before.
When we heard this bill the other day, we got so sort of wrapped around the axe line, but we never actually fully heard the testimony from everybody. So if you have other people who testify to the bill, and we also will hear from the Family Law Council people as well. I assume your part of the presentation is the same as it was the other day.
Yes, I think Ms. Russell and Tyler gave very compelling testimony. I will say that although they can't drive all the way 4 hours from Abington, Ms. Russell gives me several other examples of people she knows where this has happened. A lot of those involve someone's abusive to a girlfriend. And the heart of the bill is very simple. If you are abusive to children, if you're abusive to women, you may not be a good dad, and the court should at least be able to consider that fact in determining the custody of children. And of course, at the end of the day, the court will decide, along with a long list of factors. We just don't want courts to do, as the court did in her case, and say, oh, I can't consider this because the General Assembly has said in 9, we only look at family abuse, we don't look at non-family abuse. That's what we're trying to do.
Okay. All right, was there anybody else here to speak in favor of the bill? Anybody here to speak in opposition to the bill? Come on up.
Larry Dio, and I'm here on behalf of the coalition. We oppose the bill and its current amended version also. Other abuse is so generic, and you could have an event 20 years earlier where somebody got into a fight, and a lot of times you can be abusive between adults. And from the psychological cases I've had where I presented experts, it doesn't have a nexus to mean that it's bad for the children. There may be cases where a behavioral pattern could affect that, but to just say other abuse, I don't even know what that means, first of all.
Well, the problem is, here's the catch-22. He tried to define other abuse, and we all said, oh, defining it's causing a problem.
Well, it does, because they had stuff that it said a reasonable fear of
right.
apprehension of harm. Well, what's that mean? A mother pinches her child on the cheek too hard, the child's I mean, there's a degree. I think that factor 10, in my experience, is already used as any other factors that you can bring it in on.
All right,
had that happen. So that's our main position is A, it's covered by factor 10, and 9, you know, the court can look at.
I don't think you were here last year. We heard this
not.
bill, and Cheshire was here the other day. So the scenario that instigates this litigation is a situation where there is a type of other abuse to a non-family member, but someone who in the modern world probably is a family member, just doesn't fit one of the definitions. And the court says, I'm not letting it in because 9 doesn't allow that, and because 9 is more specific than 10, I'm not going to call it one of this catch-all things. My question for you is that a one-off decision by that judge, or is that something that you're seeing in your 40 years elsewhere?
I would say that by itself, that doesn't prove that he's bad as a parent for a child, and what's the relevance probatively?
He didn't ask that. He asked you a specific question. Do you think it is a wayward judge, or is it because you're in court every day of your life and you've been doing this 40 years that most judges get it straight, but this is an anomaly situation?
The second.
Okay.
Okay.
Absolutely.
That's what we want to know.
Yeah.
Now, what you were trying to say was, in fact, he's not a wayward judge. Maybe he didn't think it was relevant to the best interest of this child.
It would be under the factor in your scenario of the mental health of the parties, which is a factor.
Right.
And if the person has a tendency to be abusive, and you brought in some expert, because we do forensic evaluations or psychologicals, and if there's an anger management problem, a lot of times we bring in our experts to say it's controllable or it's addressed to an adult, but not children. So I'm worried that an overkill, in a sense, is trying to put a nexus of every abuse situation making it relevant to, and if the court, then you pass the statute, the court has to look at non-relevant abuse, because it says any other abuse without limit. And so we're going to have a lot of time on things that may be relevant, may not. But if you have the abusive spouse, like you said, and there's an anger problem, it's usually a pattern, you bring it into the mental health of the parties, which is already a factor. That's really where it comes in, because you're worried about that conduct that would harm a child. But we're talking about harm to a child, not abuse between girlfriend 10 years ago, 20 years ago, before the parties even married. This is so open-ended that I think that even within a definition, it would have been over.
Well, I mean, I think it's intentionally open-ended. Now,
Well,
Delegate Campbell.
Well, that's why we
Hold
oppose it.
on. Delegate
Because it's
Campbell.
going to open up a lot of time.
Hold on. Delegate Campbell.
Mr. Bell, I have a question for you. If the language after other abuse was inserted, this language is inserted, as deemed relevant by the court, would that correct a lot of your concerns?
I can't speak for the whole coalition on that one. I still think that we think that it's already covered under the position of the coalition is already covered under Factor 10. So
I understand, I've done this law for 20 years, so I know that most judges would take into account the factors that's set forth in 10. However, would you agree with me that in Section 9, it defines the types of abuse to be considered as only family abuse and sexual abuse? Specific types of abuse. Under this factual scenario, you have a mother who has a child previously and marries a new guy. And they're married for 6 months and he adopts that child. And then 2 months later, the mother finds out that he has previously, in the previous relationship, badly abused his children, not to mention his prior life. And she no longer wants to be with him. And she separates from him and seeks to have a divorce, and now newly adopted dad comes after custody. Would you not think it would be good public policy for the judge to consider the prior abuse that took place in the prior relationship in making the determination as to custody?
I would certainly think so, but the issue would be, is it already covered under Factor 10 or other factors? And I think it would be.
Would you agree that the judge could get it wrong under the statutory construction that the expression of one thing is to the exclusion of all other? And you express specifically here that only sexual abuse and family abuse can be considered. So other types of abuse might not be.
I've had success in using Factor 10, and that's the experience of our coalition. That's all I can tell you. We've had those issues, and in the limited issues that we have, that would be under Factor 10 or the mental health of the party, you could bring that in. So I still think it's already under the scope of what we have. That's the position of the coalition. Because what you're going to have then is still, where's the line in the sand on that issue? My client may say this is relevant, and you present time, cost, and the judge is going to say, now it's not relevant, and I find that it's not. So, that's still a factual determination.
Delegate Campbell.
But you said a judge 95% of the time gets it right in your prior experience.
Not 100%, but generally, yeah, I would say so.
Okay, that being the case, if you include other abuse in this as being relevant by the court, don't you think the court would be in a position to be able to make the determination whether any of that's relevant, whether the abuse was so remote in any way that it shouldn't be considered?
Problem is, it's still, what do we mean by abuse? I mean, what level of conduct constitutes other things that you can look at?
The real problem they have
That's the problem.
is other abuse raises the risk that somebody says picks up the bar fight in theory, it picks up that he pushed somebody a long time ago, is their risk, and I get it. The thing that troubles me about the case that we heard about, Tyler's case, that's so frustrating to me, is I think that was family abuse. Because when you go to look at the section that defines family abuse, it talks about abuse about family household member. When you look at the definition of household member, it's really big. It's spouses, former spouses, grandparents, children, mothers-in-law, people you cohabitate with, any child you have, any child of the person you cohabitated with. I actually think that guy wasn't a bastard family abuser that should have been admissible under the mental health, the other factors, and the family abuse section. And so where I totally agree with the goal of this, but where my concern is I actually think we may already have everything covered, and that just makes me nervous then when we tweak it of how a court's going to interpret a change. Because when a court sees a change, they're going to think we're sending them a signal. And are they going to read the wrong signal? And I don't know.
That's our concern.
I know. I think it's a legit, everything that Tyler, his mom, Delegate Levine, and everybody else has said is totally appropriate. And everything you said is totally appropriate. All right, did you want to testify to the bill too?
I'm sorry. Thank you, Mr. Chair. Sheila Varkey from Virginia Poverty Law Center, and I've talked to Delegate Levine, as well as Delegate Campbell and others of you about this bill. My concerns are what you have just brought up. Or other abuse is not a phrase that is used in custody and visitation matters now. And yes, we asked you to change that definition, but it's still too broad and vague. Using that other abuse there to allow judges to excuse factor number 6. And I'm concerned about unintended circumstances. And I'd be happy to work on language over the next year around this.
Okay. Okay. Delegate Boston? Yeah. Well, Delegate Levine gets the last word.
A few things. I was never given any substitute language by any of the groups here. I would like to have seen some. There's a very, very important part about paragraph 9 that has not been mentioned.
Yes, the subdivision 6 part.
And that exactly. That 6 requires parents to put a child with another parent and to actually support the child's contact and relationship with the other parent. By law, even when that parent is extremely abusive, unless the abuse specifically occurs to that child, you could have a man abuse 50 kids in the church basement, and the law would require that man to have custody of the child according to 6, because the only exception to 6 is in subparagraph 9.
So what it's worth, I totally disagree with that. 6 doesn't say you have to put the person with the kid. That 6 is one of the factors to consider. And 9, if you find abuse under 9, you simply don't consider the propensity factor under 6. But if you have somebody who's totally mentally unfit under 2, 6 doesn't require you to put that kid with the parent.
Well, mental condition, Mr. Chairman, obviously, and the propensity for abuse are different things.
No, what you're saying is the only way, you're saying because of 6, the only way you can not put somebody with them is if you find a violation of 9. I think that's a wrong reading of the statute. 6 doesn't say you have to put the kid with the parent except for 9. 6 is a set of factors that you don't have to consider if you find 9.
Right.
But the court could, under 1, 2, 3, 4, 5, 7, 8, or 10, still decide that the factors in 6 don't overcome it and they're not going to put the kid with them.
Mr. Chairman, the court would have to say that any parent that does not put their child with someone who is a serial abuser, 6 counts against that parent.
Just a factor. It's just one
It's
of the
one factor. Right, so factor 1 is the age, physical, and mental condition of the child. Giving due condition to the child's changing developmental needs.
The point is, 6 says, one of the factors is, as enumerated in 6, is if they take care of the kid. It's the propensity to actively support the child's conduct and relationship. 9 says, if you rape kids, or beat kids, or abuse kids, you don't have to take into account the fact that they support the kids.
Only certain kids. If you rape or abuse your own kids. If you rape or abuse other kids, the courts will say that you have to allow that rape or abuse to be with the child, or it will be counted against you.
That's not what it says.
It's one of the factors. It's one of the factors.
Yeah, it's not what it says.
It's one of the factors. So again, there's no abuse in number 1. There's no abuse in number 2, because mental condition is a separate legal concept from abuse.
Except Mr. Deal said they oftentimes use that. The history reviews, they bring an expert to show that's evidence of a mental condition, and they do use it that way, is what the testimony was. I don't do family law, so I don't know if it's right or not. Have you seen that?
We have.
Jeff? People try to use abuse of the mental condition or to style someone's done these cases. Yeah, people try to do this right. Okay. All right.
I mean, these cases are incredibly factually specific. I mean, we want the law to be broad and encapsulate as much information as we can.
Mm-hmm.
That's why.
I mean, the problem is somebody a long time ago should have said the court can consider whatever factors the court deems necessary, period. But then really smart legislators said, well, we need to make sure they consider this, and then that, and then this, and then that. And so we went from the broad to the specific.
Well, what we have here, by the way, the example about pinching and so forth, that the language that I had originally in the statute was directly from the family abuse. So it sounds to me like Mr. Neal has a problem with the current law, which says that if you abuse your own child, that's a factor because the exact factor that he had a problem with is already in the current code. And indeed, he said the fact that abuse doesn't necessarily mean that you're a bad dad. I think the court should have the discretion to take everything into consideration. And I think that that's actually what this committee believes. The court should have the discretion to take everything into consideration.
Well, I think the thing that we're all going to leave here agreeing on is that last statement. We all believe they should. And I think the question that will be reflected in the breakdown of the vote is, do we think they already do, or do we think they need another provision?
Well, the courts have said they don't. We know that in Mr. Russell's case, the court specifically laid out findings and said, I cannot consider this abuse. By law, and the court cited 2124.3, the court said, I cannot consider abuse unless it happens to the child. That was this court's finding. And actually, it's unappealable because the code says, in fact, the court does not have to consider other abuse. So courts are finding this, and you heard Ms. Russell testify as a social worker, and I can give you several other cases that she cited, that this is a frequent problem. At the end of the day, I'm saying let a court decide. Let the court hear the information, let the court decide, but to say, as the current law does, you know, we care about family abuse here in the General Assembly, and we care about sexual abuse, but we specifically exclude abuse outside of that limited category. We don't care if you abuse other children outside of your child. You just heard Mr. Gill say, you know, I don't know that the abuse is related. He said, I don't know if a man abuses a child that's not his own child, if there's a nexus, that's the word he used, to the own child. Well, I disagree with Mr. Gill on that. I think any man that abuses any child is probably not a good dad, and at least that factor should be considered by a court. In Ms. Russell's case, as you know, the court said, I'm not going to hear you. I will not take testimony. Not I'll take testimony, listen to it, and reject it as unimportant. The court said, quote, as you heard Ms. Russell say, you're trying to piggyback on that other case. And the General Assembly says you cannot do that. And that is what this court found. That is what other courts have found. And at the end of the day, what is the harm of letting a court, and you heard Delegate Campbell say, they consider a whole bunch of things. What is the harm in letting a court consider the information and trust our courts to make the right judgment, rather than say, no, we've laid out these specific factors, and giving courts a chance to say, no, I won't consider it.
So again, I think everybody agrees they need to have discretion, and the question is going to be, do people think they already have it or not, or is it a bad judge situation? And we did hear them enunciate what they think the harm is. Okay, Delegate Posse. All right, Delegate Posse moves to lay House Bill 2120 on the table. Is there a second? Is there a second? Hold on. What do you want? No, he's support. Right. What's that? Move to support.
Report. I didn't hear a second.
I know. That's what's asking me for a second. I'm trying to figure out what the hierarchy of a motion to support is.
I'll say
The motion to support. You second it.
That's a move to report.
Hold on. We have a motion to lay the bill on the table. It has been recognized. We have a second to that motion. It's a non-debatable motion. If that motion fails, then you can make your motion to. Yeah. Okay. All those in favor of laying 2120 on the table say aye. Aye. Those opposed. Okay, that's 1, 2. Are you no? All right, that motion fails. We have a motion to recommend reporting.
Motion failed.
Yes, that motion fails. We have a motion to express our support through the report. And that motion is seconded by Delegate Campbell, right? All right, all those in favor say aye.
Aye.
Oh, and that is your aye, or you're, raise your hand if you're an aye. And we know the ayes are happening, but raise your hand if you're an aye. 1, 2, 3, 4. If you're a no, raise your hand.
I'm not a bad position, I guess.
It's 4-3 because somebody didn't vote. All right, the motion to report succeeds on a 4-3 vote.
Okay.
Hope, Minshew, Kilgore, and Campbell. Delegate Toscano had left the room to go to the restroom and didn't cast a vote. All right.
4-3 report.
The bill reports 4-3.
Thank you, Mr. Chairman.
Leave quickly.
I think I saw Mr. Toscano raise his hand, but that's...
You have, hold on a second.
4-3 report. I did not have, my hand's not on.
All right, that's fine. Thank you, Mr. Chairman.
You have another bill,
I do.
but Kilgore has, this
That's
is.
a very similar bill.
Yeah, you want to hear your slap bill now?
We have a similar bill. Mine's similar to his.
All right, we're gonna start.
I like his and hopefully he likes mine.